Good morning, and thank you for joining this morning's NJCAR webinar, which will focus on COVID-19 related business interruption losses. Today you'll hear from NJCAR Risk Manager Charles Russo, Jessica Hollobaugh Giresi, I hope I pronounced that right, a partner at Withum, Eric Reed, a partner at Fox Rothschild, and Luanne Funari, an Area VP and Claims Manager at Gallagher. Our presenters will cover a variety of topics, including standard coverage types, different forms of business interruption insurance, relevant exclusions, the importance of reviewing your coverage and submitting claims, documentation needed to support a claim, state and federal legislation that may impact the industry, and more. Be a very informative hour. Before we begin, just have a few quick housekeeping details. On the right-hand side of your screen is a control panel. I'd like to point out the questions tab in particular. During the call, all participants will be muted. If you have a question during the presentation, I'd ask that you write it down. We'll give you a heads up when the webinar is winding down, and you can submit your question in the questions tab if it hasn't already been answered. That way we can focus on stuff that hasn't been addressed or stuff that needs to be further explained. Now I'd like to turn things over to Charles Russo, who will quickly set the tone for today's webinar before handing things off to Eric. Charles?
Good morning, this is Charles. One of the questions many businesses are asking today, as Brian said, is whether business interruptions and the financial losses as a result of the COVID-19 pandemic can be recovered. During today's discussion, we'll go over some of the information to help dealerships begin to answer this important question. Eric will discuss insurance, possible legislation, case law. Jessica will discuss identifying and gathering business interruption information, reasons for gathering this information, and Luanne will help discuss how to submit a claim and whether or not you should submit a claim. Before turning this over to Eric, I just want to say it's important to note that it's impossible for us to cover the topic of business interruption in its entirety today. The business interruption and the total damages created as a result of the COVID-19 pandemic mark an unprecedented situation. It is very important that you begin to discuss this with your own legal counsel, your accounting professionals, and your insurance professionals, since they really are in the only position to know your unique business situation as it relates to this topic. That said, we do have a lot of great information to share to help get those discussions started. So at this point, if Eric's ready, I'd like to turn over the discussion to him.
Thanks, Brian. Again, folks, my name is Eric Reed. I'm a litigator, mostly handle business litigation issues out of Fox Rothschild's Philadelphia office. I'm going to talk about commercial property insurance and business interruption components of commercial property insurance. And as an overall statement, I'm going to repeat this throughout what I'm presenting today. It's very, very important in considering any of these issues to be familiar with the terms of your policy, because policies are not, well, they might have some consistencies between them. They do vary, and those variances can be very significant in assessing your particular situation. So, but let's start talking about what commercial property insurance and the business interruption part of commercial property insurance typically involves. And as you see on the slide here, what you would see ordinarily in a typical case is damage to the actual business property, the insured property. That could be fire issue, water issue, tree falls, something along those lines, something that precludes you from utilizing the property because of some damage to the location. Similarly, something could happen that could preclude ingress or egress. We'll talk about some cases that involve that scenario. There are two primary forms of commercial properties, commercial property policies, that is, that would come into play here. The first form is what's called an all-risk policy, where the policy covers all risk unless it's specifically excluded. Anything that would otherwise be anything that could cause what is called a direct loss or physical damage to the property. Anything that causes that would be covered unless it's excluded later in the policy. That's bucket one. And in bucket two, we have a specified perils form of policy where the coverage would only apply if, in certain causal scenarios. So again, it's important to know what kind of coverage you have and what the specifics of your policy say. So let's talk about, in the coverage situation, what is typically provided under the policy. So it's defined differently from policy to policy, but the term, one of the terms that's utilized is net income. So if you have coverage, what your carrier would provide would be what is defined in the policy as net income. That can also be stated as net profit, net revenue. These are not necessarily accounting terms. These are terms that the insurance company utilizes, and they will be defined within the policy. But the gist of it is it's your revenue less your expenses as calculated under the terms of the policy. So you have that piece of it. If there are extra expenses that are incurred as a result of the coverage triggering condition, so the tree, for example, if there's cleanup involved, costs involved in cleaning up the tree mess and whatnot, that could get covered. Similarly, property preservation might also be provided. Again, depends on the terms of your policy. There may be an extended business interruption piece of it. So let's say your business is shut down as a result of the covered event. You get it back up and running, but it takes a while for you to get back up to speed and get back to generating money the way you had been prior to the incident. If you have extended business interruption coverage, that would cover the gap from resumption to back to your normal stride. The key component for all of these coverages, or any coverage under a commercial property insurance policy, is whether or not the triggering event caused direct loss or physical damage to the insured property. Again, I mentioned that a moment ago. I'll mention that repeatedly because that is the predicate for any kind of coverage under these policies. And different policies phrase that term differently. So I've seen it phrased as you see here on the slide, direct loss or physical damage. I've seen it phrased as direct loss or direct physical damage, or some variation of that. But while the variance of that phrasing may exist from policy to policy, what is consistent is I've never seen it actually defined in the policy. It is discussed quite a bit in the case law, and I'll talk about that in a moment. Could we get the next slide, please? So the one piece of business interruption coverage that's available under a commercial property policy is the civil authority component. And how this is a little bit different is that the damage is it arises when the damage occurs to property other than your business. So a typical scenario might be if your business is near a railroad trip line and a train derails from the tracks near your business, chemical spill, and there's a perimeter around the spill that has to get evacuated or shut down because of a hazard. That would, depending on terms of the policy, come under a civil authority because some act of the civil authority shut you down. And I'll talk a bit about some litigation that has arisen where various businesses are attempting to assert the civil authority component of their policies in the context of the COVID shutdowns. But the gist of it is, again, the damage is not to the insured property necessarily, but to related property, nearby property, and that the civil authority shuts down a perimeter for a reason that originated at other property. Now, that reason has to be the same kind of reason that would have applied on the insured property. So again, it comes back to direct physical loss or damage. There might be some time limits around what losses are eligible. So the coverage might not kick in until 72 hours later or some other time period, and then there could be a bookend on the duration of that coverage as well. I've seen it 4 weeks. It could be different times as well. But real quick, I noted a case here just as an example. After the 9/11 attacks, there were claims made regarding the United Airlines operations at Reagan Airport in D.C. Reagan Airport was not itself attacked, but it was shut down, and United Airlines could not operate there. United had made a claim under its civil authority coverage that, for its business interruption losses, it ended up not being a successful claim because the direct physical loss or damage was not incurred at Reagan or within a sufficient proximity of Reagan. There was, of course, the attack at the Pentagon. However, the shutdown at Reagan Airport was not a result of that particular issue, but rather fear of a different issue, fear of a repeat attack at Reagan. So that under the terms of that particular policy, there was no coverage according to the Federal Court of Appeals. Next slide, please. Another component of commercial property coverage that has a business interruption piece is an Ingress Egress part. And that kicks in where access to the insured property is not available because of, again, situation on other properties. So somewhat similar to the civil authority issue. The example here that I've given is this Fountain Powerboat case, and that involved a factory, a boat factory in North Carolina, out on the coast. And there was a hurricane, I think it was Hurricane Floyd, not Hurricane Floyd. In any event, a hurricane came through, did not damage the factory itself, but it flooded the only access road to the factory. So you couldn't get any parts out, couldn't get any product out, couldn't get parts or workers in. And so their business was not able to operate as it would have but for that. And there was coverage found there because of the Ingress Egress part there. Next slide, please. Another part of business interruption coverage under the commercial property policy is the contingent component, so contingent business interruption. And that applies similarly to the other parts that we've been discussing here. That applies where the damage is, again, not to the insured property, but rather to that of a key supplier or a key customer. So to use an example near and dear to all of your hearts, the auto supply line. So if you've got a tier one that is not able to manufacture do what it's supposed to do to the OEM because it can't get parts from its own tier supply chain, that coverage might apply. What's key there is that the underlying condition, there must be some direct physical loss or damage to the property of the supplier or to the key customer in that event for that to apply. And if that coverage applies, you might actually have the particular key suppliers or customers spelled out in the policy. Next slide, please. One thing that you've probably heard about if you've been following the coverage of business interruption lawsuits that have been filed is the impact of what's called a virus exclusion. I mentioned earlier on that you have essentially two components of the policy. You have the coverages and you have the exclusions. So you have the various parts of the policy that tell you what's coverage, and then you have what's covered rather, and then you have at the end the exclusions telling you what's not covered. The virus exclusion, I've put an example on the slide here. It says that there's no coverage, regardless of whatever all of the language in the coverage part. There is no coverage if the loss or damage is caused by a virus. And you see the specific language here. This language is promulgated by the Insurance Services Office, ISO. What that is it's kind of an industry standard organization it has somewhat of a symbiotic relationship in promulgating standard forms for the industry. So it can sometimes be the trendsetter, and that ISO might promulgate a provision that becomes prevalent in the industry. And the reverse is also true. If a practice becomes prevalent, ISO might issue a standard policy to reflect that. Here, this virus exclusion issued after the SARS outbreak of some years ago, and what that is offered by ISO. Not all carriers have implemented it into their forms, and sometimes there's variance from coverage to coverage and policy to policy as to whether or not the ISO virus exclusion would be included. It's not in all policies, and it's not necessarily in all policies with the same language. So again, back to the earlier point, if you're considering whether or not you have coverage available, this is a good place to start looking. Look to your exclusions portions of your policy, see if there's a virus exclusion. There is a fair number, or we have seen a fair number of cases filed, particularly in a restaurant, by restaurants and in the entertainment industries, where they're seeking coverage for business interruption, and they do not have virus exclusions. So it's not in all policies. It's worth a look. I noted here an endorsement for communicable disease coverages. That is a product that is available. I would expect that if you had it, you probably know, because it's quite expensive. It's mostly seen in the hospitality space. So for hotels, for example, might have communicable disease endorsements in their business interruption policies. So that would specifically cover, a virus type situation. So if someone comes in to your hotel and they're sick and you have to shut down the hotel to sanitize or whatnot, that would apply in that situation. That also came out of the SARS situation. So where there are losses, there are also business opportunities for insurers. It's worth a look to see if you might have that. But again, due to the cost, if you had it, you probably know about that. Next slide, please. So as I mentioned, the physical loss or damage is the key predicate to all coverage under a commercial property business interruption part. But again, the policies don't define what a physical loss or damage actually means. So you got to look to the case law. And there's a lot of pre-COVID case law that talks about that. I've included a few citations here that address some situations, and this case law certainly will be cited and is being cited in the litigation around whether or not coverage applies in a COVID context. So some things here: airborne asbestos, fumes from a meth lab, lead dust, carbon monoxide, ammonia, and cat urine. So all of those factual scenarios were found to constitute direct physical loss or damage. There are other scenarios that were found to not meet that threshold, and they tend to be very, very fact specific. But the commonality to find is whether or not the condition is demonstrably present at the property. Like, can you prove that it was there? Can you measure it? Can you otherwise establish it? All of the fact scenarios that you see above can be demonstrated as present. And then the other component is whether or not the issue renders that property unusable or uninhabitable. That was found to be true in all of those cases as well. Next slide, please. So amongst the various cases that are currently being filed involving COVID, you have essentially two groups of claimants. So you have those claimants that, as I mentioned earlier, have a virus exclusion. We saw that the ISO form. So you have insureds who are trying to seek coverage, notwithstanding the virus exclusion. and then you have the groups of folks who do not have that virus exclusion. That's kind of a rough way to separate out the two groups of insureds who are suing their carriers to seek coverage. So, and that takes different forms, and they can be bringing cases individually as an individual business. They can combine and team up with other groups of plaintiffs. There are some class actions that have been filed. And then in the Eastern District of Pennsylvania, there is what's called a multi-district litigation that's being led by some folks who operate a couple of restaurants, the Chops restaurants in Philly and the River Twice restaurant. So for those insureds that have a virus exclusion, their claim, the way that they're arguing for coverage is that they are not losing money because of a virus. Virus didn't shut them down, but rather the local shutdown order shut them down. So the municipal order or the statewide order deemed them a non-essential business, and so therefore they could not legally operate. And that's the argument that's being made by Mark Garagos. If that name sounds familiar, he's the kind of a celebrity lawyer out in California. He brought several cases for his own law firm and for some other businesses he owns, where he had a virus exclusion, and he's making that very same argument. And that's a fairly fresh case. We'll see where that goes. And in those situations, the issues that are probably going to be litigated are whether or not the insured could reasonably expect to have coverage, notwithstanding a virus exclusion in this scenario, and how a court is supposed to treat an exclusion. Typically, and the law varies from state to state, but typically exclusions are to be read narrowly. And now, in that other bucket of cases where the virus exclusion is not in play, you see, again, restaurants, professional businesses. A couple of the first filed cases there involve the Oceana Grill in New Orleans, down in the French Quarter, if you've ever been there, and the French Laundry restaurant, a great restaurant in Napa Valley. They have policies that did not include a virus exclusion. And then the issue there is simply whether or not the shutdown, the business interruption resulted from a physical loss or damage to the property. So they got to prove that their shutdown, the origin of that shutdown, be it by way of the government order or otherwise, is attributable to physical loss or damage to property, either in their own particular property or under a civil authority theory, under the civil authority part, a sufficiently adjacent property that would fit the terms of the civil authority part in their particular policy. And so in those cases, you see allegations about the longevity of the virus, the prevalence of the virus. It's everywhere, and it lives for days, and where people can prove it, that they had actual employees or customers in their business place that had come down with the virus and perhaps had developed full-blown coronavirus or full-blown COVID. Next slide, please. I want to talk a bit about some legislative efforts to address this situation. Right now, there is a proposed legislation kicking around the Assembly in New Jersey, and that proposal would essentially retroactively deem every property policy with a business interruption component as covering COVID-related business interruption losses. So, notwithstanding a virus exclusion, we are going to deem that the COVID is causing a direct physical harm or loss. So, we'll essentially moot that issue, and it would do that for policies in effect as of March 9th of this year, and for smaller insureds, so insureds with less than 100 full-time employees in the state. There's going to be pushback on that. There's already been pushback on that. And part of that pushback is constitutional. There's a constitutional argument under the Contracts Clause, which states that no state shall pass any law impairing obligation of contracts. Now, there's case law, of course, that's developed around that, and the case law says that it's okay for the state to act if the action, one, is not a substantial impairment of the contract, and two, if the law is reasonable and appropriate in terms of advancing legitimate public interest. So, taking your contract and retroactively rewriting it, arguably is a substantial impairment of that. That'll get litigated. But in whether or not the law, this proposed law, is reasonable and appropriately tailored to advance a legitimate public interest is going to be also litigated. There's certainly arguments to be made on either side of that. The other issue, the other legislative approach that's being proposed right now, there was a bill proposed by, I believe it's Congresswoman Waters from California, that would essentially mirror the response to the 9/11 claims and create essentially a federal reinsurance fund. And then there'd be parameters around it that it would be triggered when the industry losses exceed 250 million. That's pretty far in the rear view at this point. But what that would do is essentially create a reinsurance fund so that the carriers have something to draw upon in order to pay claims. Short of that, if there's just legislation that's deeming these claims as covered, in addition to a bunch of bankrupt businesses, you're going to have a bunch of bankrupt carriers. So this was the way out in the terrorism, post 9/11 terrorism coverage. It might be the way out here. We'll see what happens with that. Next slide, please. So quickly, I want to give you just a few practical takeaway tips to summarize some of this. Again, very, very important to know your policy language. Figure out whether or not you have that communicable disease part. You probably know if you have it, but check anyway. See how your civil authority part of your coverage defines what's available there, and see whether or not you have a virus exclusion. Because if you have a virus exclusion, you're going to have a much tougher path to get paid if you're considering that. And then if you're in a situation where you want to make a claim, then the later presenters will be talking about the specifics of that. Get a hold of your accountant. Get a hold of Jess, will be talking in a moment here, and get some expert analysis of your situation so that you can make the most informed and supported claim possible as you can. And you're going to want to remain mindful of your claim deadlines. Your policies sometimes identify when you need to make a claim, and if you let it get too stale, you could waive rights. And then again, consult your accounting professionals about what kind of documentation you need to keep. And with that, I will turn it over to our next presenter.
Thank you, Eric. That was great. I love when I get to do these webinars and learn something at the same time, and I think you had a lot of great information there. Again, I am Jessica Hollobaugh Giresi. I'm a partner at Withum, and I focus my practice on all litigation support, typically retained to prepare economic damage claims, which includes business interruption claims. And, as Eric spoke about throughout the morning, the focus has really been on whether there is coverage or not. So what I would like to briefly touch upon is two-part. One, if there is coverage, the loss calculations are anticipated to be significantly more complex than a typical property damage claim for business interruption. And two, what documents should businesses start accumulating now in order to substantiate any of those claims later? So first, there are going to be some considerations in these potential COVID claims that are going to be relevant, which really haven't existed with other disasters, at least to the extent that we feel that they're going to with COVID-19. And I believe that one of the main arguments that insurers are going to make is that many businesses may have suffered decreased revenues during closure, but that decrease was mitigated or somehow recovered when the businesses were allowed to reopen. So essentially what the insurer's argument will be is that the decreased revenues weren't totally lost, but instead, majority of them or some of them were pushed into a future period. And although mitigation is always a consideration, we just expect it's going to be more of a consideration and more widely argued by the insurers in relationship to the COVID-19 business losses. And I'll give you an example, which I think will help demonstrate what I mean. So assuming your normal auto dealership, there's a fire and that dealership needs to close for a period of time. So during that normal property damage, consumers in the market for a vehicle aren't sitting around and waiting for your particular dealership to open to purchase that vehicle, right? So instead, what do? They drive down the road 10 miles and purchase a vehicle from a dealership up the road. So in that instance, it's fairly clear the dealership that had the fire lost the sale. There was a normal customer ready to purchase, the dealership closed, and they went somewhere else and purchased the vehicle. So now fast forward to COVID-19, right? And that same auto dealership is closed, but now they're closed because of one of these government mandates, and they're closed for a period of time. The problem we see here is during this time, other dealerships within that very same area, and often a very widespread area, entire states and surrounding states, are also closed. So that person that in the last example drove up the road 10 miles to purchase a vehicle can't do that now. So what insurers are going to argue is that because everybody was closed, that there's somewhat of a pent-up demand, and the dealerships didn't lose all their sales because of closure, but instead, when they reopen, they have the opportunity to mitigate those losses because the consumer hasn't yet purchased. So I think that's one of the main issues that we're going to see. And then beyond that mitigation argument, we also now have an economy that's been declining throughout these whole COVID-19 closures. So the insurers may also make some arguments surrounding what portion of your losses are a result of the COVID-19 closures and what portion are just a result of those general economic turndown. And in order to segregate those two, it's going to be very difficult. And don't get me wrong, on the other side of the coin, the dealerships are also going to, and other business owners are also going to have arguments. In this example, where the insurance company is trying to claim mitigation, the dealership may have an argument that they didn't have the capacity upon reopening to both handle that current sale on their reopening and additional sales because of pent-up demand. So the point of this slide is really just that the business interruption losses are difficult concepts, and COVID-19 has certainly made them more difficult. And if there ends up being coverage, the claims are going to require a significant amount of documentation and analysis. And that is really going to need to be done on a business by business basis. So we don't envision any two of these claims being identical. They're going to be really unique to each business themselves. So that being said, businesses really should start to maintain their documents now to support those calculations later. And that brings us to the next slide, which outlines some of the, can we just click to the next slide, please? There we go. Outlines some of the documents that will be needed. So we discussed this mitigation issue before that we feel the insurers may use to minimize their claims. And in that instance, in order to determine whether these subsequent sales have mitigated past losses, the final claim calculations may not occur until several months post-opening. And we know that once restrictions are lifted, the focus of these businesses are going to be on reopening in their current business structure and not necessarily on collecting documents for a business interruption claim. So we think it's really important at this time to begin organizing that documentation that we're going to need later, so we're not playing catch up at that time. In any business interruption claim, you're going to need your basic detailed accounting records, your financial statements, your tax returns, your general ledgers. For dealerships, you guys have something very unique that's very helpful in terms of business interruption, and they're those monthly dealer statements that are provided. So obviously those accounting records are something you already have. They're nothing really to accumulate now, just to keep in mind, you know, not to fall behind on your bookkeeping and entry and everything that needs to be done, because you will need those documents. And then specific to COVID, we always suggest that you maintain a timeline of what's occurring. So right now, a timeline and support for all the governmental orders, any supply chain impacts due to plant closures, or any other issues that are impacting your business during the closure. And upon reopening, it's much easier and more accurate when you accumulate this information in real time than trying to go back in the future and figure out what happened when. And then documentation of additional costs incurred. So you want to make sure that you're maintaining records of any additional costs that were incurred solely as a result of the closure. So a cost that you incurred, but you wouldn't have incurred had you remained opened. Some of those could be, you know, if your dealership, for example, is handling, you know, online sales of vehicles. Are there additional expenses relative to those online sales that we wouldn't have had to maybe set up an additional technology to handle those sales? If there's additional security costs, those type of things. And as these costs are being incurred in real time, do yourself a favor and separate them in your general ledger postings, or maintain a detailed list now, because again, it's much harder to go back, you know, 6, 9 months, a year later and try and figure out what all these costs are. And not only is it easier, but we find that when people do it real time, their claims are generally higher because they don't miss things that they otherwise would from going backwards. Details of any loans and related interest costs. So if you have any loans or interest specific to the closures, and then identification of any changes in profit margins. We kind of talked about that. You know, if you're doing online sales and they are less profitable for some reason than normal sales, we'll want to break apart and we'll want to understand why they're less profitable so that we can compare them upon reopening. So really the overall concept here is just accumulate the documents now and accumulate all the support now, because when you try to recreate the wheel later, it's much more difficult and oftentimes less accurate as well. And I think at this point, Luanne is going to take over and talk a little bit about what the claims process is going to look like.
Good morning. This is Luanne Funari. I'm with Arthur J. Gallagher, and I am the Mid-Atlantic Area Vice President and Claims Manager. So we're just going to talk a little bit about claim reporting, and I'm going to start off with the types of claim notices that we are seeing. A couple of those are the notice only or potential claim notice, and the other is, of course, a formal claim notice. So I just want to give a brief definition of those two types of claims. I'm sure most of you are familiar with this, but a notice only or a potential claim means any circumstance that may reasonably be expected to be the basis of a claim. It means any matter reasonably likely to lead to a claim under or claim covered under a policy. And contrary to popular belief, reporting potential claims rarely affects insurance premiums. So we do encourage you that if you believe that you may have a claim, to at least put the carrier on notice of it. Failure to report a timely and accurate claim can be costly if later on the insurer decides to deny for late notice. Formal claim is a request by a policyholder to an insurance company for coverage and or for compensation for a covered loss or policy event. The insurance company will then validate that claim. If it's covered, once it is approved, they will issue payment to the insured or an approved interested party on behalf of the insured. I can tell you that with respect to the COVID-19 claims, most policyholders are reporting formal business income losses under their property policies. And if they are have contamination and have had to have cleaning or disinfecting expenses, that many of them have also placed their environmental pollution policies on formal notice as well. You heard earlier about the various types of coverage issues and exclusions that are in the policies, but because of the pending litigation that is out there, most insurers have decided that it is better to place the carrier on notice now. So when we get a call to place a carrier on notice, what we're looking for is your date of loss. And that date of loss is going to be either the date the loss of the income began, the date of your office closing, or the date of your federal state emergency, or the date of stay-at-home order. Can be any of those. Most people are using the orders as their date of loss, but we do have some clients that closed prior to state of emergency or stay-at-home orders, and they're using earlier dates. So something to think about when you're placing the carrier on notice. We're looking for the primary insured contact for investigation purposes. And typically we have a general description of loss where we're just saying business income loss as a result of COVID-19. And then just the expectations once the carrier is placed on notice, or after the claim is reported. Typically what happens is one of two things will happen. The carrier will either send a reservation of rights letter with an information request form, or they'll send an immediate denial based on the information provided. Jessica, explained to you what information is needed, and you'll see if you receive an information request form that they will request all of that information that that she told you about earlier in this call. They're also going to want to know if there was direct physical damage to the property, if there was contamination. It's a pretty lengthy form that we're seeing that needs to be filled out and sent back. Once a coverage determination is made, if there are exclusions, which most of the policies do have the virus exclusion in it, typically we're seeing denials. And then we take that denial, your insurance broker should take that denial and review it against the policy language to check and to find out if there are any coverage arguments that can be made to turn that denial around. We haven't been too successful so far on that, but hopefully if this the pending litigation is successful, then some of these coverage denials will be overturned at that time. And that's basically all I have.
This is Charles. I would just like to say that Gallagher has a lot of really great information online regarding mitigating business interruption and extra expense claims, and they also have a claims guide. So if you're interested in those links, email me at crusso@njcar.org. That's crusso@njcar.org, and I'll get that information over to you. And if everybody's ready, we can go and answer some questions. So, Brian, if you want to.
Well, yeah, if anybody wants to submit questions, we don't have any submitted yet. So if there's anything that wasn't covered or that you'd like to have explained further, I did actually have one for Jessica. During your part of the webinar here, you had mentioned, you had discussed potential insurance company arguments. Use the example of, like, if there was a fire, one dealership at a dealership, they would lose sales to the dealership down the road versus every dealership in the state is closed. These are sales that are probably just going to be delayed. That being said, what about the border, the states, the dealerships that are on the borders? Because Pennsylvania and New York are both currently allowing by appointment sales. Where NJCAR is hoping New Jersey will do that very, very soon. But that argument, I mean, in that case, there is another place that consumers could go to. Can you speak a little bit to that about whether that's a different? Do they maybe have a better argument?
Absolutely. So, and that's why I said, you know, these will be on a business by business basis, because I think that's a great example, is a dealership that is on the border of another state that's open. Those consumers do have the opportunity. So when I say maintain a timeline and maintain details of governmental orders and things that are impacting sales, that would be a very specific fact that we would want to make sure we maintain. You know, we were closed on between X date and X date, but, you know, Pennsylvania, which is 5 miles up the road, was able to reopen. So I think that would be a very strong argument, you know, against the insurer's mitigation argument. So I think that's a really great point.
Okay, great, thank you. And I think that's good. I gave some time for other people to submit some questions, so I have a couple more here. And just feel free to, whoever, I'm not sure who these necessarily go to. Are you recommending to file a formal claim during this time? If you file a formal claim, will it increase your risk of policy increase? I think somebody had mentioned that, but maybe give a little more information on that.
I guess that's a question for me, and well, it's hard to answer at this time. You know, your producer is going to go to market on these when the account renews. So, you know, we're seeing increases in general even before COVID-19, but this is going to make it, you know, a little bit more difficult. It doesn't mean that there is going to be an increase, but you know, I think that it's going to be tough if everybody's filing these claims, and you know, there's so many more claims. The industry it as a whole is going to struggle with this.
Right, and this question may kind of overlap that. Given what you said about ongoing suits, should dealerships file claims now?
Well, if they believe that they have a loss, then yes, they should file that claim. If they want to file it if they're not sure if they're going to have a loss, then they should report it as a notice only. Even if the claim is reported. Go ahead.
Also, I think from a risk management standpoint, regardless of whether the claims are covered or not, you want to collect this information and quantify this information for your business. Again, like Eric had said, things may change down the road. It's going to be, if these claims do for some reason get overturned and paid, it's going to be on a first come, first served basis. So I think businesses want to consider those things when gathering this information.
And I do want to say that even if the claim is filed as a potential claim, the carrier may still reach out to talk to the client to see if they should conduct an investigation on some of these. They may or may not do that, but so if you're unsure whether you have a documented loss rate now, but you may at another time, then you should at least report a notice only.
Also, you know, there is, as Eric had mentioned too, there are certain coverages in the restaurant field that would respond to this. Gathering that information again and finding out as a business how much you actually lost through this pandemic will allow you to make the determination to look at that coverage if it's available to you. And regardless of the expense, you know, the expense might be much less than what you've suffered here. So again, from a risk management standpoint, I would suggest that's another consideration for getting this information together to be able to make better decisions in the future on purchasing insurance. Because hopefully this will never happen again. But if this does happen again, or this comes back around again, and a shutdown becomes necessary, then maybe you know, it's something that you you may be able to have coverage in place in the future. So just something to consider. Sorry, guys. Thanks.
No problem. By the way, everyone, we will be posting the slides and a recording of the webinar to our website later this afternoon once it processes. So you can, and if you just need a copy of the slides, feel free to email me at bhughes@njcar.org. Also, if anybody has any other questions here for either Charles, Eric, Jessica, or Luanne, we have one more here, but if anybody else has anything else they want to chime in and ask about, feel free. In the meantime, everybody, here's the next question. Do you anticipate the receipt of the Paycheck Protection Program funds being used in loss calculations?
So the receipt of the funds, obviously, if it's just a loan, no. But if there is a forgiveness related to COVID-19, I think it would be a reduction to the losses.
Okay. I'm surprised. I thought we were going to get more questions. We don't think we have any more, but if anybody does have any, as you can see, everybody's email address is on this last slide here. So feel free to contact them directly if you have any questions that you think of after the fact. So if nobody else, if none of the presenters have anything else to add, anything else, any final thoughts from anyone?
I think we did a pretty good job of covering it.
Okay, well, thank you to Charles, Jessica, Eric, and Luanne, and thank you to the participants, the handful of you that did give us questions. Thank you for those questions. And that concludes today's webinar. Stay safe and thank you.